Now we consider real, demonstrative, and experimental evidence. This material is not very important according to the National Conference of Bar Examiners. You won't see many questions on the multi-state from this body of law. It is much more important on the essays, and there's an excellent chance you'll see issues on evidence essays from this area of law. Real evidence is physical evidence that's directly connected with the case, the gun, the drugs, the mechanical object which is the subject of a product's liability action. That's real evidence. Demonstrative evidence is designed to illustrate the case to a jury, and experimental evidence is almost directly connected to expert testimony. Experimental evidence is supposed to do research into some of the physical issues presented by a case, and then present that to the jury. Let's consider real evidence in a little more depth. The relevance of real evidence generally is pretty obvious from the circumstances of the case. So the gun used in a murder obviously is directly relevant to the potential criminal liability of the defendant. Circumstantial evidence also can take the form of real evidence. Although the relevance of many physical objects of evidence is apparent, there are certain counterweights to relevance, and in particular, the possibility of unreasonable prejudice or unfair confusion is much greater with regard to real physical evidence than it is with regard to, say, testimonial evidence. The big issue with regard to real evidence is authentication. This is the issue that's tested over and over again, both on the multi-state and especially on the essays. And what makes authentication a little complicated is there are a couple of different ways to authenticate a physical item. The most obvious and easiest way to authenticate a physical object is for a witness to just identify it. So if we've got a physical object which is easily identifiable, like, for example, a manufactured product that has a serial number on it, then all we need to do is have someone come in and testify that they can recognize the object and that, in fact, it does have the correct serial number on it. Also, if we've got a unique chattel, like an antique, certainly that object readily can be identified by anybody who's got an interest in the case. But where we've got an object that is much more generic, like, for example, drugs, or a bullet, or some other item of physical evidence which is basically fungible with all other similar physical objects, under those circumstances, we need to be able to authenticate the object via chain of custody. And I like to think of chain of custody as being very much like the baton in a relay race. We've got to start the race at the moment that the item of evidence becomes relevant, and then we have to be able to follow every hand-to-hand exchange from the moment the object becomes relevant until the moment the object is discussed in open court. Now, in practical terms, what this means is each custodian of the object has to come to court to authenticate his or her step in that chain. Then, once we've authenticated the item, then we have to present evidence that the physical evidence in court is in essentially the same condition at trial as it was at the time that it became relevant to the proceedings. Next, we consider demonstrative evidence. Now, many outlines consider real evidence to be just a subset of demonstrative evidence, and that's not unreasonable. Demonstrative evidence is a generic classification given to evidence which a trier of fact can perceive without substantial reliance on the testimony of witnesses. Now, one aspect of all testimony can be considered demonstrative. Obviously, if a witness takes the stand, he or she is going to testify as to certain facts, and the jury will judge whether or not those facts are true. But the demeanor of a witness could be considered demonstrative evidence. You can look at somebody talking without being able to hear the words and make certain judgments about the person who is speaking. So, putting those impressions aside, we consider other forms of demonstrative evidence. Here what we've got in mind are tape recordings, photographs, movies of relevant events. And this is becoming increasingly important because there's so many automated recording devices in public and in private. The way that we authenticate this evidence, which is almost always going to be pretty obviously relevant, is either by bringing in the person, the technician who's responsible for the equipment, and have that person testify that the recording is accurate, or by having someone present at the scene at the time the recording was made testify as to the accuracy of the contents of the recording. Another form of demonstrative evidence is pictures, maps, or models which illustrate the relevant event. All of these graphic illustrations, accident reconstruction depictions, ballistics tests, etc., are admissible, but they have to be accompanied by testimony that relates them to the relevant event or place. So, to be admissible, maps or models or diagrams have to conform at least to the party's theory of the facts in all of their essential details. Photographs, which are taken after the event, may depict conditions which have changed in the interim. They'd still be admissible if a witness can point out the changes and then testify that, except for them, the photograph is an accurate depiction of a relevant scene. Similarly, X-ray photographs are admissible if they are authenticated by a doctor or some other expert who can testify as to why they are relevant. The testimony of the photographer who took a particular picture isn't necessary to introduce the photograph. But when we get to best evidence, which is going to come up in the next video when we consider documentary evidence, we'll see that best evidence principles can apply to many types of demonstrative evidence. It's also true that the trial judge has the discretion to allow demonstrations to be conducted by a witness in front of the jury. Finally, briefly, let's consider scientific evidence. Scientific evidence counts as part of real demonstrative and experimental evidence. But right up front, we have to acknowledge that this material is directly connected to, and it's really a part of, expert testimony. So in a couple of videos, when we get to testimonial evidence, we'll consider expert witnesses in a little bit greater detail. But here, scientific evidence is admissible for a party to produce experimental or scientific evidence if this evidence will help the trier of fact to determine or resolve a fact at issue. The probative value of most experiments depends on their similarity to the conditions that are actually at issue in the case. So the most common test to determine whether or not an experimental test that is produced out of court is admissible in court is where the conditions where the experiment are conducted are substantially similar to the conditions at issue in the case. If the experiment relates to the composition or analysis of some relevant piece of evidence, there's no problem of similarity presented. The relevant evidence itself is being analyzed. This is typically illustrated by a test of a substance to determine whether or not it is an illegal drug. It's worth mentioning that the results of tests are not rendered inadmissible if the opposing party doesn't participate in conducting them, or if the court doesn't supervise them. We'll take another look at some of these issues when we get to expert testimony in a couple of videos. That's it for real, demonstrative, and experimental evidence. As you practice, I think you'll find that this material is some of the most straightforward and intuitively sensible stuff on the outline. Don't neglect it. There's points there. Next, we're going to continue a lot of the threads that are present in real and demonstrative evidence as we get to documentary evidence. That's the topic on the table in the next video.